feel more comfortable up there, that's up to you. Whatever you feel comfortable. I don't think it was here. I can't remember. I don't know if there's anything here. I don't remember. I guess we're, all
Good morning, everyone. My name is Helen Bernstein. I'm Counsel Program Development at the Law Society in the Department of Professional Development and Competence. Welcome to today's program, the Youth Criminal Justice Act. 1 year later, the program's being seen live to our audience in Toronto, as well as to a number of locations across the province along our interactive learning network. We also want to mention that the program has been accredited by the Criminal Law Specialty Committee of the Law Society for 3.5 hours towards the professional development requirement for certification. If you're attending at an ILN site, we hope you take the time to check your name off the attendance list. We encourage people to fill in the grade course evaluation form in the file, and we want to mention that the program is being videotaped. When the panel is taking questions at the end of the program in Toronto, just raise your hand. If you're at an ILN site, the operator will contact your site during the break and just indicate if you have a question, and we'll go to your site during the question period. Finally, we want to thank our two chairs, Rick Blouin, who's Assistant Crown Attorney, Youth Court Manager, and Sergio Giacomini, an experienced defense counsel. As well, we thank all the members of the faculty for all their help in putting the program together. I know you're in for a very interesting morning, and I'm going to turn the podium over to Rick.
Thank you, Helen.
Good morning and welcome to the program, the YCGA 1 year later. A little over a year ago when we did this program, myself and my co-chair at the time, Brian Scully, as he was then known, when we did this, we didn't have the benefit of any case law on the YCGA, and in preparing for the session we did last year ago, January, we read the act as many times as we could possibly stand, and one recurring question came to us each and every time, which was, what the hell does this mean? And that happened over and over again, and hopefully today we're going to, through the benefit of the information and the panelists have here that will be given to you today, we'll be able to at least try to answer some of those questions or put you in the right direction to start to answer the questions. As you know, the YCGA has 200 sections. It's very complicated. With the 3 hours today, Sergio and I, we're going to try and focus on the major areas that we all deal with day to day in our practices, and those being the ones that this act is impacted most upon are, of course, sentencing, measures, extrajudicial measures dealing with cases out in the community, and bail. If you can take the act and distill it down to two major thrusts or two major themes, I think it's that the legislators wanted everybody to firstly not use jail as much as it had been used in the past, to look to alternatives to custody. So there's a fair bit of the legislation that deals with that aspect of the principle. And then there's the other principle of quite frankly, we're using the court system too often to deal with youth justice issues, and we can deal with a lot of things out in the community, not in court. And in fact, in Scarborough, where the court that I manage, we've been doing that well before the Youth Criminal Justice Act with, I think, very good results, dealing with cases out in the community and freeing up the court time for the more serious cases. We're going to change the format slightly. You'll see that there's essentially Sandy Lang, Deputy Minister, is going to speak to you first, and then we're going to do a panel on sentencing, and then Sergio is going to do a panel on bail. And then we have a section called Engaging the Community. Miriam Blumenfeld was scheduled at the end to do a kind of a review of the cases that had been decided across the country. And what we've decided to do is actually slot her into the panels on sentencing and bail, because obviously what we talk about in sentencing and bail is impacted by the cases that have been decided, and really nobody has chronicled and cataloged the cases like she has. So I think it'd be very beneficial to have her as part of each panel, and we're going to do that. And she still will be around, I think, to speak about any other cases that weren't dealt with in the sentencing and the bail panels. So that's where we're going to go today. I'll turn matters over to Sergio. Sergio's going to introduce Sandy Lang to you.
Good morning. Next to me is Sandra Lang, and she's the Deputy Minister of Children's Services, which is now dealing with Phase 1 and Phase 2 youths. Sandra Lang's been in public service for over 25 years. She's been Deputy Minister of more than one government department, and she holds degrees, I see here, in psychology and applied criminology. The new ministry, as indicated, will be dealing with both Phase 1 and Phase 2s. There's going to be a lot of logistical issues that are going to be coming up, obviously. It's, I guess the idea behind it, one of the major ideas, of course, was to streamline the whole Phase 1 and Phase 2 and just deal with children from ages 12 to 17. Without going further, I obviously don't have the insight that Ms. Lang has in this area. I'm going to ask her to speak about it and speak specifically about the transfer responsibility and how will things change now with this new ministry as opposed to before. As you recall, it was slightly different.
Thank you, Sergio. Good morning, and thank you for your interest in the youth justice area. I'm going to spend a few minutes this morning just sharing with you a little bit about the creation of this new ministry, what it's all about, and then talk to you more generally about where we're going or where we think we're going in the whole youth justice piece of the ministry. First of all, this was a creation of the new government, started last fall when the McGuinty government was elected, and they decided that they wanted to have a department devoted entirely to children. And so they've created a ministry, or we're in the throes of creating a ministry that will be focusing its energy, its policies, its legislation on children and youth. When we first launched the ministry, it was the Ministry for Children's Services. And during the course of the winter, we've spent a lot of time, the minister and myself, traveling around the province, talking with people, getting a significant amount of input about their issues and concerns in terms of what we're doing with children in this province. And one of the first things that was said to us when we were chatting with these various groups was, where are youth? Why aren't youth featured in the name of your ministry? And so as a result of that, we decided that it was important to change the name of the ministry so that there was a clear understanding that we were dealing with children and youth, and that youth would recognize themselves some way, shape, or form in this government department. So the ministry has been formed. It is responsible for all children between the ages of 0 and 18. It is a ministry that is focused not only on program delivery and policy and legislation, but it's also a ministry that will be responsible for shaping a fairly major strategic agenda for children in the province, helping us work with our partners in other ministries, with other levels of government, to get a plan in play that will deal with where we want to be able to invest our energies and our money and our policies as it relates to the success of children in the province. We are looking at a framework for policy and legislation that will deal with children as they go through the developmental stages of their life, starting with prenatal care right through to the transition into whatever form of independence comes post-high school. The developmental stages are an important approach to how we develop policy, because we know that the earlier you provide support and intervention, the better the results are for our kids and our families. The other thing is that we want to be able to make that transition from the various developmental stages in a child's life as smooth and as seamless as possible. So that is the other thing that's important to share with you as we think about the shape and the priorities of this ministry is that we're going to be putting a fair amount of time and energy into research. As a government, I think it's fair to say that we haven't invested as much as we should have in research to tell us what works and what makes a difference and what are the things that we need to know about as we're investing incredibly important public resources in our programs and services out there. We're also going to be doing a fair amount of work on outcomes. It is our belief that we should be reporting to the public on how our kids are doing on a regular basis. And so we will be defining what are the outcomes that we want for our children, what are the things that we need to measure, and be able to assess whether in fact the investments we're making are making any difference at all. And that will be an important part of the ministry's policy and program framework. The way in which we started to approach this exercise was to take a look at what are the programs that need to transfer into the new ministry. And I'll just briefly share with you what those are. We've taken a significant number of programs from other ministries, and we now transfer them in as of April 1st. From the Ministry of Community and Social Services, we have transferred all of the children's programs that were dealt with under the Child and Family Services Act. So things like child welfare, children's mental health, child development, all of those things are now part of the ministry. The whole area of childcare and the early years, all of the early intervention programs that were part of new federal money that came our way in the last few years, dealing with children between the ages of 0 and 6. From the Ministry of Health, we have transferred over children's treatment centers, which are programs designed to deal largely with young people that have physical disabilities. Children's mental health programs that were still left in hospitals. We've taken over the outpatient programs. We will be looking at some of the inpatient programs in the fullness of time, but that disentanglement is a little more complicated, I have to say. All of the early years stuff, the public health activity out of health, the Healthy Babies, Healthy Children, which is a program with the public health community where we do early screening for new babies, speech and language services, audiology services, all of those services that are dealing with community-based service for children and families. And from the Ministry of, well, I call it Correctional Services. I can never remember the name of the ministry, but from that ministry we have transferred over all of the youth justice activity. So the phase 1, phase 2, so all of the programs dealing with the 12 to 17-year-olds, both in terms of the custody and the community services, probation, etc. And we have transferred all of the staff associated with that program and that service. So those programs have transferred, the money has transferred. The budget for this new ministry will probably be about somewhere between 2.8 and $3 billion. So it's a significant size organization, and there are a lot of programs and services dealing with children. The other thing that we've made a very clear point of doing is ensuring that this ministry is linked in with other ministries, because we know that the success of our kids is highly dependent on our ability to get other organizations to be focused on the same agenda. And the one area that's critical is education. We can't have the kind of success we need for our children if we're not tied into education in a very significant way. And I can assure you that the kind of discussions we're having with our colleagues at education at the moment are incredibly productive and very positive. So we're doing a lot of joint work together. We've just announced in the last few weeks a major initiative dealing with autism. And some of you may be familiar with that difficulty out there, but the program that we've announced is largely dealing with helping schools, school boards, and teachers deal with the needs of autistic children in the classroom. And there's a significant amount of money that's been set aside to work with the school. This is quite a historical shift, quite frankly, because traditionally we've just sort of turned things over to the schools and said, well, it's now your baby. The reality is, if we're going to do the kinds of things we want to do for children and families in this province, we need to do it together, and we need to do it in a way that we're integrating services and not kind of continuing the silos of separate services out there. So I think that signals an indication that we are going to be continuing to work very closely and very collaboratively with our folks at education. The other thing we want to do, and I hope that this new government will pursue this in a very aggressive way, and that is open the schools up again. Make the schools a real resource for our communities, and look at how we can utilize those facilities to be able to provide a whole range of services and programs for young people in this province. So there will be a number of initiatives, I hope, in the not too distant future where we're starting to talk about opening the schools up again and making the schools available for the kinds of programs and services that have been, in our view, so critical to the development of young people, both in the context of community activity, but also in terms of community services out there, having an ability to serve kids in the schools rather than separate and distinct programs outside of the school system. So we're encouraged by that one. That one is looking very positive. The ministry has now been given its budget. It has been given approval for its staffing and for its structure. We are a ministry that's going to be devoting a fair amount of time and energy to policy. I think it's fair for us to say that the policy agenda in the last several years has been fairly limited, and we haven't focused as much time and energy on policy as we need to. We have been, from my perspective, spending a lot of time on what I call initiative-itis, and we have all kinds of initiatives out there, but we have thrown a lot of money around in terms of various programs and services, but they're not connected and they're not part of any real policy strategy that I've been able to determine. So we're going to be spending a lot of time on a policy agenda that deals with the shaping of the strategic plan that I've just alluded to earlier, as well as getting down into some very specific program policy agenda items that have to be attended to. Children's mental health in this province is in dire need of direction, and we need to spend a fair amount of time and energy sorting that one through. We have, as I said earlier, a lot of time has been given to the early years, and a lot of money has been given to early years initiatives across this province, but they're not connected either. And there are a series of disjointed programs and services out there that need to be brought together. There is also a fair amount of work that we can be doing with special needs children. We did a little bit of a think tank piece the other day where we were looking at special needs children in the province, and those are kids ranging from mental health, physical disabilities, you name it, those kids that require some special services and special attention. And we found that we had 17 pages of programs for special needs kids. 17 pages. That's bizarre. If you're a parent in this province and you have a child with a special need, it is a nightmare trying to find out where do you go and how do you get access to the kinds of services and supports that those young people need. We have to clean that up. So there's a very big piece of work, and that includes the educational system, because we also have a lot of money being spent on special ed in this province, but we've never evaluated it. We don't know whether it's making a difference to the lives of those kids or not. So there is a big piece of work to be done on that front. So we've started to shape our agenda. We're in the throes of developing the strategic plan, and we've moved quite aggressively in trying to get this new ministry up and running. On the youth justice side, what we've been doing so far is getting our plan in play to deal with the whole new youth justice legislation, as well as an attempt to integrate Phase 1 and Phase 2. As you may be aware, this province has had two separate entities dealing with youth justice for a long time, and we've now brought them together under one single ministry, and we're trying to bring a lot of integration to the Phase 1, Phase 2 area. We're also in the throes of doing some very active, what do you call it, disentanglement, if you like, of, or decommissioning, I think is the term we use, of many of the facilities where we have young people in adult jails. and trying to look at how are we going to create a separate and distinct set of programs for young people. I'm sure you're aware that we made a decision in the not too distant past to close TIAC, a facility here in Toronto, which in my view is, well, I probably shouldn't articulate what my view is on that, but it's definitely not something where I think we should be providing service for young people. So we will be looking at hopefully creating a whole new facility in the Toronto area for young people, dedicated to young people, and in a manner that is conducive to our view of rehabilitation. I think it's important that people understand that there is a desire on the part of this new government to deal with the young people in a way that recognizes their need to account for their behavior, but also to recognize that they need to have the benefit of investment and intervention in a way that hopefully will be rehabilitative, as opposed to further educating them in the world of criminal activity. So we're going to be putting, I think, a fair amount of time and energy into alternatives. I don't think it's any secret that we have spent a lot of time and money in this province dealing with putting kids in custody, but we haven't put a lot of time and money into preventing kids from needing to have custody as the only alternative to deal with their behavior. So there will be, I think, a fair amount of emphasis over the not too distant future where we start reinvesting again in community services, in alternatives to custody, and start to, as much as we can, back up the system. So we're putting much more emphasis on prevention, early intervention, and hopefully finding solutions to the needs of these young people. If you have opportunity, and I would strongly recommend if you have an opportunity to do this, you visit some of these facilities where we are housing these young people, you'll discover, as we have, that many of these young people who are in these facilities can't read. They haven't had, for whatever reason, the benefit of our educational system. Their learning disabilities are significant. And it's not until they get to some of these facilities that they're actually getting the right kind of educational assessment, and we're beginning to see that those young people have missed an entire educational experience because for whatever reason they've either been passed through the educational system or they somehow magically managed to get their way through several years of education without really learning. And they're now starting to benefit from some of the programs and services in our custody facilities to learn to be able to deal with basic kinds of skill development, which will hopefully give them some assistance as they think about either going back to school or moving into the workforce. One of the things we're doing in some of our facilities, which I'm very pleased to see, is an emphasis on apprenticeship and trying to work with the apprenticeship community across the province to see if we can help, particularly the older youngsters who are 17, 18, 19, to get them into some kind of a working responsibility, a job or an apprenticeship where they can actually begin to develop a trade. So there is going to be, I think, a fair amount of energy and emphasis placed on early intervention, prevention, alternatives to custody, but where we are dealing with the need to house youngsters in custody, that there is some rehabilitative focus and some aftercare. One of the nice parts of the new legislation, if I understand it correctly, is that there is an expectation of post-custody care and support. So we will be looking at what needs to be done on that front as well. So we're pretty excited about this new ministry. We're looking forward to being able to invest a significant amount of resources into the front end. As you know, we have had a reduction in the number of young people sentenced to custody, and as a result of that, we have some current capacity to redirect some of those resources now into community-based alternatives. And as I've traveled around the province and talked with folks, it's been fairly clear to me that people are crying out for alternatives. People want additional kinds of resources. They want to see programs and services in the community for our youngsters, and they want it now, and they want it to be very much focused on helping prevent those young people from having to get further into the youth justice system. So that's sort of a quick snapshot of the state of the new Ministry for Children's and Youth Services. We've been busy for the last 6 months, and we have a very aggressive agenda, but I think a lot of support on the part of this government to do something quite different in dealing with our children and our youth.
Thank you, Sandy.
I would, I know that we've used up time, but I'm quite happy to take one or two questions if that would be helpful.
I'm interested if you're going to be doing anything with the Safe Schools Act.
I was asked to repeat the question, so I'll do that, although we all heard in Kenora and other places, they may not have heard. Is the ministry going to do anything with the Safe Schools Act?
I hope so. It's not our ministry's legislation, but I know that our minister has talked to the Minister of Education, and I know that the Minister of Education has been hearing quite loudly that there needs to be something done with this legislation. As we've traveled around the province, we've heard so many times, particularly from the educational community, that the Safe Schools Act is not helping. If anything, what it's doing is it's forcing kids out of school as opposed to dealing with their issues. So I'm hopeful that the government will take that one on.
I'm just wondering, you mentioned that you're consolidating, and we heard this, that it was April 1st, the youth worker for phase 1 and phase 2 kids, so it'll be all under one program. But I know in Scarborough, for instance, we still have the 2 programs going. And I've had a situation with a town autism program, and the child was old enough, he was in phase 2, he was in whatever it is, the phase 2, but where the older kids go, I don't know the difference, phase 1, phase 2.
Yeah.
And the youth worker said, I've never heard of this program, I'm not doing it, so I said, fine, I'll take it to the other youth worker, but I couldn't because she said, no, he's my client, and it became a political pick of football, so when is that all really going to be consolidated?
Well, I'm hopeful that it will be, and probably within the next 6 or 7 months. We're in the throes now of just trying to figure out how do we start integrating these things. For example, in phase 1, there's a lot of emphasis on open custody. In phase 2, we don't use open custody, and I don't know why, but it's just because we've had 2 different cultures and 2 different worlds dealing with this system. So we're in the throes now of taking a look at what are the things we need to bring together. Can we look at the various programs and services out there and deal with the needs of the kids and not deal with this notion of one is phase 1 and one is phase 2. It's going to take us a little while to get through that kind of morass and shift the way in which services are provided out there, but it's certainly our intent. But it will take some time. I hope in the next 6 or 7 months you'll see some beginning change in that, and more kind of sharing of resources between the phase 1 and the phase 2.
We're going to try and keep on schedule if we can. So we've got a lot to cover, and it's a nice day, and I'm sure people don't want to stay here much longer than 12 or 12:15. Sandy, are you going to stay around at all? Or
I'm afraid I'm on my way out, but
she's out to play golf. What a life. All right, thank you very much, Sandy. Appreciate
thank you.
it.
Thanks very much.
Could I ask the sentencing panel to come up, please? I'll tell you that we're going to go a little longer with the sentencing panel because Miriam's being added to it in the bail panel, so we'll go a little longer than the times indicate, and I guess we'll take the break at the most appropriate time. So. What's that? Oh, really? All right.
Hey, there's a good book, eh? No. Might as well, if everybody else.
All right, I'll introduce the panel to begin with, and I'm not going to spend much time doing this. All the CVs and the bios are in the materials, so why waste time doing all of that? You can read, but I'll briefly say Justice Gilles Renaud is a judge in Cornwall and has been for, I guess, 9 years now, and he's written a book on practical guide to sentencing, and it looks like I think I see it there just to your left there on the left side of you. Is that?
That's Peter Harris's excellent text.
Oh, it's Peter Harris's. Is yours been published now, or is it?
I'm told next week.
Next week. Okay. All right. This is starting to sound like a talk show, isn't it? Where we're plugging the books and everything. It really wasn't intended to be that way. But to my immediate left is Miriam Blumenfeld. Miriam is the lead for the implementation of the YCJA for the Ministry of the Attorney General, the Criminal Law Division, and the fairly substantial compendium of cases decided that's in the materials is prepared by Miriam and Margot McKinnon at the whatever office that is downtown. I never know for sure what goes on down there, but it's a very useful guide, and we're happy to have Miriam here. And as I say, she's included in this panel, but not the bail panel, as I understand, but in the sentencing panel. So. Welcome to Miriam. To my immediate right is Ted Yoannou. Ted, excuse me. Ted has been involved in youth court matters for over 10 years now as a defense lawyer. He's just purchased Mr. Justice Telek's practice and is well over his head in terms of the number of cases he has to deal with, and has hired a number of different people to help him out. And so I think he has about half the youth court matters in Toronto. So Ted's got lots of experience doing youth court matters from the defense side. On my my far right is Justice Peter Harris. Justice Harris has been a judge for 9 years as well. Has been in Scarborough, I guess, the last 6 years. 7 years. Seems like more, I'm sure.
To you.
Yeah, to me. Notice he's not wearing his usual flak jacket that he wears when he travels into Scarborough, but. He's been involved in youth court matters, as anybody that's done youth court work knows. He's written manuals and been very much involved in educational programs on the, yes, and there's the plug, youth court matters throughout the last number of years, and before being a judge as a defense lawyer, specializing in youth court matters. So we'll start the panel I'll start by saying to you that the part that we're dealing with here, sentencing, I think is the primary important part of the act. I mean, it's the sections that have most changed things, and there are new sentences, there are different ways of doing custody now, there are different principles, there are windows into custody, all of those things, and I think they've fundamentally changed the way we do business in youth court. It used to be, and I did defense work for 12 years, before going back into the Crown's office, it used to always be the question, and even if you're not doing youth work, if you're doing adult work, and the question was always, am I going to jail? They want some sort of opinion on that. And while under the Young Offenders Act, it was very difficult to know. I mean, and it still is to some extent difficult to know. We can now tell with some certainty that you won't be going to jail. And the first thing we're going to deal with are the windows into custody, because if it doesn't fit within one of the four windows under Section 39(1) of the Youth Criminal Justice Act, the Crown cannot be we can ask for custody, but the legislation does not permit a custodial sentence. I'll start by asking Justice Renaud, with respect to 39(1)A, the first window that that you can get into custody is the issue of whether it is a violent offense, because if it's a violent offense, a custodial term, and we'll deal a bit later with what custody means these days, because it's not custody, it's custody and supervision. But we'll ask about that definition of violent offense. Justice Renaud.
Thank you very much. The first comment that comes to mind, I'm surprised that someone got paid to hand over files when I became an assistant crown attorney and wanted to sell my youth clients. I paid someone to take on the files, so the world has evolved somewhat. The definition of violent offense is a very difficult one. The paper prepared by my colleague Peter sets out at paragraph 4 the cases that strike the controversy between the PEI Court of Appeal and the Alberta Court of Appeal, so I don't need to cite those. In the paper I drew, I looked over the Quebec cases, which have not reached the Court of Appeal level, in which this is a very, very significant controversy. The pro-defense argument is that it must not only be violent, it must be a violence of a degree that almost brings it into the serious violent offense. The other cases that are percolating up, and they're set out in the material, so I need not review them at length, suggest that the French language text is what should be looked to. In the French language text, 39(1)A reads, "L'adolescent a commis une infraction avec violence." That is to say, the young person committed a violent offense in circumstances of violence. So it's the circumstances that matter. And the cases I set out in the materials, which I won't bore you with, seem to indicate that what's important is let's protect people from the possibility of harm. Now, in Peter's excellent text and in the articles we have, the suggestion is that that is just too broad a category. To adopt that definition would basically undermine the restraint principle. I think that there's maybe the compromise situation that will come up is simply this. We're going to extend, I think, by adopting what I think is a sensible definition, violent infraction, infraction with violence. But that does not mean that the person is subject to custody. It simply means that it's a violent offense. And then you plug in, I would suggest, as defense counsel, the submission that it doesn't set aside the principles of restraint that infuse the legislation. But I think if we say of a break-and-enter offense, where the young person knew there was someone in the house, there was a potential for confrontation, a greater potential for fright, why not say it is a violent offense? Because it strikes me intuitively as a violent offense. It's an invasion of one's domestic peace. But that given historically how we've dealt with young people committing this type of offense, as young adults before, we would try to avoid them having any kind of custody. The Majewski cases, a great number of other cases. So why not simply make the submission that it is violent? But it certainly is not a justification from doing away with all the restraints and the use of custody. The Court of Appeal decision from Alberta strikes one, I think, as being a bit too impressed with the importance of ensuring the community thinks that violent offenders go to jail. Well, I'm sorry, that simply is not the policy of the Youth Criminal Justice Act. It doesn't seem to be the situation. And now that the English language translation is available, that lengthy decision from the Court of Appeal of Quebec striking down some of the provisions, they repeat and repeat the fact that we have to see this legislation as something as a new Jerusalem. It's a new way of looking at the world. All kinds of work has gone into this. Consistent with adult policies to have a check on the use of incarceration, let's be consistent, and let's be more consistent. Let's give the young people an opportunity to avoid all the negative collateral consequences of incarceration. So at the end of the day, I'm sitting firmly on the fence. The definition of violence should be enhanced to embrace what we normally see as being violent. But unless it amounts to something much greater than that, where there is significant harm, why should the person be subject to a period of custody when the legislation cries out against that principle?
Thank you, Joe. The second window into custody is under 39(1)B is failure to comply with non-custodial sentences. I'm going to ask Ted Yoannou a couple of questions surrounding this. Firstly, does that include, when they talk about failing to comply with sentences, does that include dispositions under the Young Offenders Act?
Thanks, Rick. This subsection is, for a rather short subsection, it raises a number of issues. It states that a young person shouldn't be committed into custody unless the young person has failed to comply with non-custodial sentences. If we remember the language from the previous act, the Young Offenders Act, young people weren't subject to sentences, they were subject to dispositions. The first issue that comes up is, did the act mean to include previous Young Offender Act dispositions? When it didn't say so, it says sentences. While there's some arguments that can be fashioned to say, no, it shouldn't include previous Young Offender Act dispositions, the case law seems to support the notion that yes, it does. And I think logic maybe supports that as well. It wouldn't make a lot of sense if there's a young person who's had 10 prior breaches of probation under the Young Offenders Act, but doesn't fall under this window. And I think the case law supports that, and there's some nice decisions in Miriam's body of work that's included in the materials that take you through that. But it's funny how it's not worded very well, this subsection, because in the very next subsection, C, it talks about the pattern of findings of guilt both under this act and the Young Offenders Act, and you wonder why didn't they just put that same language in subsection B for greater clarity?
Is it more than one when it says sentences? Is that taken literally? Is that plural? Could it be just one sentence?
Again, I think it's yes. The answer is yes. It has to be at least 2 prior sentences.
And when it says failure to comply with non-custodial sentences, does it have to be a finding of guilt? In other words, there's a breach of probation or a breach of disposition or sentence on the record, or can the Crown just produce evidence that even though there was never a finding of breach, that in fact the person was on a non-custodial sentence before and didn't comply with it?
My answer is I'm not 100% sure, and maybe some of the other members of the panel could help out. When you first look at it, I think everyone envisions the idea of if you've had 2 prior findings on your record, then the window's open, you could be placed in custody. But there's a few different scenarios that come up, and how you answer that, how you respond to those scenarios depends on how big this window is. If a young person's on 2 probation orders, so there have been 2 prior findings of guilt, and he's on 2 probation orders, now charged with a new offense, does that open, and let's say the new offense is a theft under, but also charged with 2 breaches of probation, the 2 probation orders, and let's say the breaches are only breaches of the statutory terms, keep the peace and be of good behavior. Does that open the window further where the judge might say, well, there's the 2 findings right there. You've committed a 3rd offense and you've breached 2 prior dispositions or 2 prior sentences. And I think maybe the legislation failed a little bit in not really being more specific on that. I think, and having reviewed some of the materials in preparation for this, I think the argument can be made, yes, that could open the window. That doesn't mean the person's going to custody necessarily. We still have to keep in mind the intent of the legislation and the overall principles and also the particular circumstances of that young person, but arguably that could broaden the window further. Conversely, a nice argument would be, you know what, for greater certainty, so the young person knows what's going on, consistent with the policy or the purpose of restraint with respect to the legislation, there should be prior findings of fail to comply so that everyone knows what we're dealing with. But on the subject to what my fellow panel members say, I think arguably it could be broader so that a person who has actually no breaches or no findings of fail to comply on his record could be liable to it just for the fact that they're on 2 probation orders.
The third window is into custody. Again, it's only allows custody, it doesn't mandate it, is a pattern of offenses under 39(1)(c). Justice Harris, what does a pattern mean?
Okay, because of the separation of powers doctrine, it's inappropriate for a judge to comment on the merits of legislation, so I'm not going to tell you what I'd like to do with the
Thank you. Next question.
people that wrote this section. But first, I refer you to paragraph 6 of my paper, and we're going to apply a contextual analysis here. 39(1)(c) speaks of a history indicating a pattern of findings of guilt. Extremely clumsy expression. Let's break it down into small pieces. History, Webster's dictionary says, a record of past events. So why not say prior record? Let's assume history means prior record. Pattern is defined in Regina and Langevin, Langevin, 1984, 11 Canadian criminal cases, 3rd, 336, Ontario Court of Appeal. This is a dangerous offender application in respect to which the criminal code refers to a pattern of repetitive behavior. Pattern of repetitive behavior is then defined by Justice Lacourcière. He defines pattern as follows. This element is not based solely on the number of offenses, but also on the elements of similarity of the offender's behavior. So introduces the concept of similarity into pattern. So pattern in the YCJA arguably means, by analogy, repeated offenses with elements of similarity. The third key interpretive clue is the French version of 39(1)C. Plusieurs déclarations de culpabilité. How do you like that accent, Gilles?
It's very good, Peter.
This means several findings of guilt. So I say several means at least three. If they wanted to say two, they would have said two. Several, I think, means three. So let's bring it all together and create a composite definition that's understandable. Prior record. So we talk about a history indicating a pattern of findings of guilt. Let's say a prior record of several, at least three, similar types of offenses. That breaks it down to something we can understand. Now, just one last comment. To be consistent with the gatekeeper function of Section 39, which I say is designed to reduce the over-reliance on incarceration, I submit that 3 prior property offenses doesn't amount to a pattern. In my view, it has to be at least 3 similar offenses. Now, it could be 3 thefts, it could be, and it could be 3 similar kinds of violent offenses. But if you talk about property offenses generically, I think you could end up with shoplifting, arson, and unlawfully in a dwelling house, all property offenses, but no similarity at all. And I say, in order to maintain this gatekeeper function of Section 39, the 3 or so offenses you're talking about have to have some similarity to them in order to establish a pattern. Thanks.
The final window into custody, and again, these are disjunctive. It just has to be one of these. It doesn't have to be 2 of them or all of them. But the final one is D, exceptional cases. Miriam, what's an exceptional case?
Well, maybe I'll just start by quickly reading the section. It's slightly less opaque than the one Justice Harris was describing. It talks about exceptional cases where the young person has committed an indictable offense, and the aggravating circumstances of the offense are such that the imposition of a non-custodial sentence would be inconsistent with the purpose and principles set out in Section 38, which of course invokes, several other subparagraphs that you need to be familiar with in order to interpret this section. It has been referred to as a basket clause, and certainly the case law indicates, and I would also suggest that it's just the opposite. It really is intended to only apply in the most exceptional of cases where they don't fit into one of the other categories, but it is very, very clearly a case where custody should at least be considered. There are no Court of Appeal decisions as of yet interpreting the section, but most of the lower court decisions that we've got so far seem to follow that logic. I'm only aware of 2, and these are only the reported ones that I know about, where the exceptional case category has actually been used to allow for contemplation of custody. One of them was a very serious arson at an elementary school causing about $30,000 worth of damage, and that was in BC. And the other was a sexual interference case against 4 different individuals, and that was in Newfoundland. In contrast, there have been several other decisions where the argument has been made that this should be an exceptional case, and it's been rejected every time. One where it was a theft of 2 compact discs. That was in another province. Let's see, 2 more in sort of property types of offenses. One of them relatively serious, involving 7 different break-and enters into seniors' residences, and 2 drug-related cases, and 1 sort of gang imitation knife point robbery in Saskatchewan. The interesting thing about that is that what I'd sort of heard about the rationale for this clause was that one of the things that it might be used for was drug cases. And so far, it really hasn't seemed to have been applied, at all, frankly, in that context, except potentially in some unreported cases that I don't know about. So this one is really let's watch and see what happens kind of section.
All right, I'm going to move on now to, as I mentioned before, there's no custody sentence anymore. It's custody and supervision. And what it breaks down to when a judge orders custody and supervision, 2/3 of the sentence is served in custody, and 1/3 is served in the community. Firstly, what is community supervision, Ted, and what are the rules that apply to a young person who serves that last third of his custody and supervision order in the community?
Okay, well, take you through the act a little bit. The sentence that we're talking about is under section 42 sub 2 sub n, and that's the custody and supervision order, and it's this 2/3, 1/3 breakdown. So a young person receives a 6-month custody and supervision order, serves 4 months in custody, and then 2 months in community supervision, which may or may not be followed by a period of probation. The community supervision order is governed or overseen by the supervisor who in effect is the probation officer. What happens is there are mandatory terms under section 97(1), and I won't take you through them, but those are under subsection 1 are the ones that are included in every community supervision order. And then there's also under subsection 2 the provision for additional conditions to be imposed. Practically speaking, what happens is my understanding, what happens is the probation officer meets with the young person and a number of other people within 30 days of the order to put together a reintegration plan, and theoretically or hopefully in practice, it's a comprehensive plan that involves the young person, family, school, the custodial officials, and other people who have an interest or have input into the young person's well-being. And they put together this reintegration plan. Part of that plan is the community supervision order. And it's apparently reviewed monthly and reviewed just days before the young person's release from custody so that it's timely and specific to the needs of the young person.
What happens if a young person breaches that community supervision aspect of the sentence?
Well, there's under section 102 and following is the regime for how breaches are dealt with, and it's an area of some concern or of to the people involved in it because it's not well set out the process in terms of how it's dealt with. If there's a breach under 102, under sub A, the provincial director has some discretion to allow the young person to continue serving his sentence in the community, and sort of in the way that either ignore the breach or deal with the breach but still under the community supervision regime so that they can vary the terms or add conditions. Or if the breach is deemed more serious, the young person may be ordered into a youth custody facility so that a review can be conducted. Where there's some uncertainty is the actual mechanics of how that review happens, and there's some concern that the Crowns aren't properly notified. There's some delays. There aren't provisions for a young person perhaps receiving bail subject to that review, and there's some concerns that it's not moving along as quickly as possible. But aside from that, the theory of it is there's a review before a youth court justice, and it's then determined will the young person continue his sentence under the community supervision order, or will he be sent to custody to complete either the balance of what's left. So in the first example I gave you, if there was a 2-month community supervision order and if it's breached in the first 2 weeks, the power is there to send that person, to the young person, into custody at the maximum the 6 more weeks to make up the sentence. But the youth court justice has the discretion from no custody to the full amount or to something in between.
Miriam, the aspect of and using Ted's example of 6-month custody and supervision, 4 months in custody and 2 months in community supervision, can the judge decide, or does the judge decide of that 4 months whether it's served in open or secure custody, and can that 4 months be a blended secure and open custody sentence?
But if you're brave and determined enough to actually read the legislation, likely you'll conclude that the judge no longer has the discretion to decide if it's going to be closed or open custody, because sections and sections of the Act are dedicated to setting out a very complicated administrative scheme for correctional authorities to make that decision. But there's this one teeny little section, Section 88, which says if the province chooses, it can actually import the parts of the Young Offenders Act which allow the judge to make that decision. And in fact, every single jurisdiction across Canada, including Ontario, has made that decision, so that's what we do here. So if you actually want to look at those sections, you need to have both the YCJ in one hand and the YOA in the other hand, so it can become kind of a complicated exercise. Section 24.1 sub 2 of the YOA, which is the section that talks about how the judge goes about imposing closed or open custody, actually specifically says that the court shall specify in the order whether the custody is to be open or secure, which might sound as though it means it's got to be one or the other, so you can't combine open and secure. And I talked to the woman in Ontario who's basically responsible for figuring out sentence administration for all youth. And she said to me with a sigh that in fact it is supposed to be that way, a choice of either or, but that since the beginning of time, the courts have been interpreting it to mean that you can combine closed and open in one sentence, and that the sentence administrators will do what the courts say. And also she commented, and I think most people would agree with this, that the intent of the combined orders is very logical because it does allow for a more graduated reentry and rehabilitation into the community, you know, as you progress through less restrictive levels of custody. The only comment that I've heard about that is that perhaps now that every custody sentence actually includes a period of community supervision, it may be that it's less necessary in some cases to actually combine closed and open. And the final comment that I'll make is that one situation where it gets difficult to really reconcile the closed and open combined sentences is when you have to come up with a sentence for sort of multiple offenses or a subsequent offense. Then the sentence calculations of the legislation, which are challenging to begin with, become, they might make you cry at that point. But generally, from a policy perspective, I think a lot of people agree that it's appropriate to continue to misinterpret that section of the YOA.
I'll ask the two judges on the panel, and we'll use Ted's example of 6 months custody and supervision. If you felt that was the right sentence, 6 months of custody, but now it's custody and supervision, which includes the third community part, is it all right to then mark up the sentence to 9 months so that you get 6 months in custody and 3 months in the community? Is that okay to do that?
The short answer is no. The long answer refers us to 39.8 of the legislation. But you'll remember the Willard decision back in '67. The fellow committed a particularly repugnant act, and in the course of the sentence, the judge says, well, you're going to need 6, 7, 8 years in the penitentiary to straighten out. And given the parole system, I'm giving you 12 years. So there was nothing covert about his thought pattern. The Court of Appeal, of course, said you can't do that. More recently in '79, you may remember the Luther decision where the person was sentenced to 12 months in order to receive the mental health assistance that was necessary and that was thought to be available somewhere in our custodial system. And the Court of Appeal decision is to the effect you simply can't inflate a sentence for purposes of treatment. And we have that specifically set out in many places in the legislation, Section 29, Section 38, Section 39. The other difficulty is simply it's brings us back to JJM, where the Supreme Court said, well, basically you want to do what's right. That's how I interpret that decision. If you think that programs are available and will be of assistance, well, those programs should be available outside of a custodial setting. And certainly given the legislation, if we have to send someone to custody to get a program, then I'd rather say as a judge, nothing can help this person in custody, and I'm not going to send them to custody for a program. I'd rather they be outside receiving some assistance, and if that means that there will be some difficulties, we'll have to deal with that. But I think at the end of the day, it's wrong to inflate a sentence to meet needs, but it is perfectly appropriate to decrease an otherwise appropriate sentence to avoid some collateral difficulties. The way we reduce, for example, a 100-day sentence to a 90-day sentence for an adult to permit weekend sentences or things of that nature, but never to inflate.
And 39.8 does specifically prohibit doing that. It deals with that. Justice Harris, what portion credit do you give for pretrial detention under this act?
Well, it's a complicated issue. I generally deal with it just the same way that you deal with an adult sentence, where if generally speaking, somebody would be entitled to statutory parole after two-thirds of their sentence and could be eligible for early parole after a third. all these calculations have worked out traditionally in practice to mean that you generally consider a 2-for-1 credit. I don't see the Youth Criminal Justice Act as any different. It seems to me that with the 2/3, 1/3 parameters, you have your typical statutory release after 2/3 of the sentence, and under Section 94, youth can apply for a review anytime after, well, with leave, anytime, but certainly at 1/3 of the sentence, a youth could apply for a review and be released at that point, just in the same way that an adult could obtain early parole. So I don't see any different. I think the calculation ought to be 2-for-1, but I could see that there's a whole lot of other considerations in this that have to do with the availability of programs in custody and the conditions of some custodial facilities like TIAC, and in the right kind of case, based on the conditions that have been existing there for some time, my calculation could well be quite a bit more than 2-for-1.
Right. I just should say that there's a number of cases that you'll find in Miriam's materials that talk about a number of the judges in various provinces use a 3-to-2 relationship. In other words, you know, if you do 6 months of pretrial detention, it's like a 9-month custody and supervision order, so I'll give you credit for 9 months. That's sort of what a number of judges are saying, but you can look at those. Next thing we're going to deal with is adult sentences. We're going to try and get this done in the next 25 minutes, and we've got a number of topics to cover. An adult sentence is an important part of it, but it's not one we use on a regular basis, but I think we should at least touch upon the issues that are dealt with. In adult, in a case in youth court, is there a transfer hearing as there was under the YOA, Ted? And I'm going to ask for short answers, relatively short answers on these, so we can keep moving. Okay. No. Ted's quite right. There's no transfer hearings anymore before trial. The sentencing is, and whether it's an adult sentence or a youth sentence, is done afterwards. Which offenses qualify for an adult sentence? Justice Renaud?
I'm worried about my answer. I can't find anyone that don't, but I'm worried someone is going to raise their hand and say, what about this and what about that? Essentially, the whole field is open. I do recommend page WT6 of Peter Harris's guide, which sets out the little boxes setting out the elections, and the recent Canadian Journal of Criminology and Criminal Justice, April 2004, which is dedicated to legislation, in particular pages 314 and 316.
All right, and there are offenses that are presumed to receive an adult sentence. The Crown can always apply, given there are some basic preconditions, but the presumed offenses, which ones are they?
I was worried you were going to ask that.
Okay.
Murder, attempted murder, manslaughter, aggravated sexual assault, 67(1)(a).
Okay.
I'm always worried about these answers.
And there's the other third serious violent offense, which we're going to try and deal with a little bit more in the deferred custody, because it seems to kind of come into play a little more when we talk about deferred custody sentences. With respect to, Justice Harris, with respect to getting an adult sentence, does the Crown need to give notice to get an adult sentence?
This is another sterling example in the act of remarkable clarity. You want to watch you don't get whiplash in your neck trying to follow the cross-referencing between 67(1)(b) and 64 sub 1, sub 2, sub 3, and sub 4. The short answer to all of this is that Crown has to give notice if it seeks an adult sentence for a non-presumptive offense and the offense carries a criminal code maximum greater than 2 years and the youth at the time of the offense was 14 or older. That's from section 64 sub 1 and sub 2. Second place, the Crown has to give notice for an adult sentence when it seeks an adult sentence for a presumptive B offense by proving the offense is a third serious violent offense. If you want to know the timing of those notices, you have to attend a seminar for about 3 days and then study 64 sub 2, sub 3, and sub 4. It's very, well, I don't think anybody knows what that means.
In terms of the elections as to mode of trial, if it is going to be an adult sentence, Miriam, can you talk about the elections that a young person might have and where the trial might be held if elected?
Well, yes, I can.
Thank you very much.
A young person is entitled to elect mode of trial anytime he or she is charged with murder. So it doesn't matter whether or not an adult sentence is even sought. Anytime the charge is murder, then the young person can elect. Anytime that the young person may be liable to an adult sentence, so where the Crown's given notice that it will seek an adult sentence, where it is a presumptive offense, or where it's unclear that the young person, whether the young person was under or over 18 at the time the offense was committed. And Section 16 of the legislation talks about those circumstances where you're not really sure whether the YCJA would have applied because of the young person's age at the time of the offense. So in any of those circumstances, the young person may elect, and he or she has three choices on the menu. One would be a provincial court judge without a preliminary inquiry. The second is a preliminary inquiry followed by a trial in Superior Court by a judge alone, and the third is a preliminary inquiry followed by a Superior Court judge and jury trial.
I'm going to speak a bit now about the new sentences that are in the Act that were not part of the Young Offenders Act, and we'll just try and go over some of the new ones in fairly quick order if we could. Firstly, there's an offense for young people where an absolute discharge is really too strong, a judicial condemnation, and that's called a reprimand. It's before the absolute discharge. What is a reprimand? And I guess I'll pose that question to the two judges on the panel. What's a reprimand? What do you consider to be a reprimand?
Some judges point out that a reprimand is a way of looking at the Crown and admonishing them for bringing a terrible prosecution. That's a reprimand. Legally, the reprimand is my attempting to be a stern uncle and in an avuncular fashion looking down at a young person who typically is taller and bigger and saying what you did was not appropriate. On the train yesterday, I was reading a biography of a political figure who I can't name because they're disclosing a youth record, who spent the night in custody after painting on the asphalt in front of his girlfriend's house, "Happy Birthday." And his father came over and said, "I'm not taking him home." He spent the night in jail. He showed up in the youth court that morning, pleaded guilty, and this is under the old legislation. The judge said, "Next time, write her a letter, send her a card. You can leave now." That, I suppose, is the best example of reprimand. He was arrested, his father came to the police station, spent the night in jail, was embarrassed. What more is there to be done? I really don't know more, and I'm hoping Peter can enlighten me on what a reprimand is.
Okay, well, aside from the scolding that Gilles is talking about, I guess there's two areas that I think reprimand works well, where it's been, I guess the process has been enough to hold the youth accountable, whether it's pretrial custody, strict bail conditions, the results of a conference, the number of court attendances. The court may say all of that has been a proportionate consequence. Or secondly, where the court wishes, as Gilles says, to make a statement about trial delay, the youth treatment in custody, maybe that the case should have been diverted to EJS&M.
EJS&M? Yeah, I like that. I've never heard it combined like that. But
Some kind of bondage club, yes. Okay, so
I'll ask another question, which is one that comes up all the time, and it shouldn't be an issue, and it shouldn't be difficult, but it seems to be. Is it all right to give a conditional discharge, and as part of that conditional discharge, impose a term of probation?
well, okay, the answer is no. Okay, do you want to go to
And
the next?
and that is the answer, believe it or not. You can't impose probation with a conditional discharge, just to avoid your embarrassment when you're in court asking for it. There are conditions that can be attached to the sentence, and probation monitors it, and there can be a reporting condition to probation, all of those things, but it just isn't a probation order. Why would they do that? I mean, like, it seems to make no sense at all, and if anybody can explain it to me, maybe later, because we don't have time. Miriam can, but we're running a little late.
Practically speaking, if I can.
Just one thing. Go ahead, Joe.
No, under 4211, but it's practically speaking, the record access period is influenced by that decision, so it does have consequences for your client, even though it may not appear to be the case. So you want to fight for the conditional discharge when you can.
They used to think you had to have probation associated with a conditional discharge to give you supervision and enforceability. Well, if you look at section 42(2)(c), that's the conditional discharge section, you can actually have in that section, on a conditional discharge alone, the youth reporting to the provincial director. And so there's all the supervision in there you need. And under section 137, if the youth breaches the conditions of a conditional discharge, the youth can be prosecuted for fail to comply with a sentence under 137. So there's enforceability as well. So you don't need probation. Problem with probation and conditional discharge is they both have different record access periods. So if you want to give the youth a shorter record access period of a conditional discharge, you combine it with a probation, you expand the record access period, and it's just inconsistent. It doesn't serve any purpose at all.
Okay, I'm sold on that then. The next thing I wanted to speak about, and I'm going to ask Ted this, there are some optional programs that the province can opt into or not. There's one called Intensive Support and Supervision Program. It's in the Act under 42(2). What is it exactly, and is it available in Ontario? And if not, is there an idea of when it might be?
Right, it's under L. 42 sub 2L, and it's not yet available in Ontario. I understand it should be 3 pilot programs are due to be in operation sometime soon in the coming months. I think there's some debate or discussion in terms of which model to follow. There's a number of different kinds of models. One type of thing that's, I think, in place in some areas is something called community support teams, and that's the idea of there's sort of a 24-hour support available, and I guess the youths that would be ideal or targeted for this type of sentence would be youths who are described as having high needs. A woman I spoke to about the program, sort of called it a small youths needing sort of small T treatment, and youths who sort of slip through the cracks of what's available. And they're young people who need lots of supervision. So the one idea is if there's probation officers overseeing this type of program, those probation officers would have a smaller caseload. I don't know what a typical caseload is, but let's say it was 50 cases. Maybe this probation officer might only have 10, but they're involving kids whose needs are a lot higher, so there could be a lot more one-on-one attention.
Can I just add one thing very quickly with respect to the ISSP, the Intensive Support and Supervision Program? My understanding is that the people who are thinking about how it should be crafted are all very excited by the fact that Youth Justice Services are now at the new Ministry of Children and Youth, because they feel that that's going to allow them to be a lot more creative and make use of a lot more different kinds of programs and services and approaches than might have been available at the old ministry. So I wouldn't be at all surprised if we see 3 pilots with 3 different formats and structures, and they really see what is the most useful and the most preventative and the most proactive.
Attendance program, that particular sentencing option under 42(2), what is that, Ted, and is that available?
Yes, it's under sub M, and it's a sentence or an order where a young person would be required to attend a non-residential program. Guidelines are set or stated that for a maximum of 240 hours, and it's for a period not exceeding 6 months. Right now there's 4 pilot projects operating, and they've been in effect since the beginning of this year in Thunder Bay, Brantford, Peterborough, and Toronto. There's been a number of other programs that have been operating in the past. I think at one point it was high as over 30, and I think it's down to 9 or 10. But they're programs that address a wide number of needs. In Toronto, we're familiar with its Operation Springboard or through Turning Point, and they deal with it could deal with a number of issues that young people need to address, including anger management, life skills, employment training, residence issues. So
we've got somebody from the attendance center that's from the Scarborough one. Mark Schuler is going to talk about that later on. Okay. Thanks, Ted. The IRC sentence, the Intensive Rehabilitation, Custody, and Supervision sentence. Miriam, what shortly and briefly, what is that exactly, and what are the preconditions to getting one?
Do I have to talk really fast?
Very fast. Faster.
Okay, I'm freaked out. Okay, intensive rehabilitative custody and supervision, that's the IRCS sentence, and look at sections 42 sub 2 sub R and 42 7. Okay, quick trivia fact, I know we don't have time, but section 42, the sentencing section of legislation, has 50 subparagraphs, and these are 2 of them. The conditions precedent for receiving this kind of sentence, which is really intended to be a very heavy-duty, rich, intensive treatment sentence, is that the young person needs to have committed one of a very limited series of offenses, very serious ones: murder, attempted murder, manslaughter, aggravated sexual assault, or a third serious violent offense, as defined in Section 2, Sub 1 of the legislation as an offense in the commission of which a young person causes or attempts to cause serious bodily harm. And if you want to know more about how that's been interpreted, there are pages and pages of jurisprudence summaries on that in the materials that you've gotten. In addition to having committed one of those offenses, the young person needs to suffer or be diagnosed as suffering from a mental illness or disorder, a psychological disorder, or an emotional disturbance. As well, a plan of treatment and intensive supervision has to have been developed, and there needs to be reasonable grounds to believe that the plan might reduce the risk of the young person repeating the offense or committing a serious violent offense. And the provincial director has to have determined that this program is available and the participation by the young person is appropriate. It's important to note that just because a young person receives this kind of sentence, he or she does not lose any of the rights that were available to withdraw consent to any kind of treatment. So theoretically, a young person could be sentenced to IRCS and then decide that he or she is no longer interested in pursuing treatment. The thing that you need to know about this sentence is that the federal government will pay up to $100,000 annually per young person over and above the ordinary costs of administering the sentence, and that money is to go specifically towards providing this sort of intensive treatment. Unfortunately, it appears that in the first year out, the sentence has really been underutilized, or at least it hasn't been used nearly as much as the federal authorities had hoped. Exactly. Only 2 in Canada, and that's a tiny fraction of the number of cases for which they'd set aside funds. We've had 1 assessment request so far in Ontario, and in that case, the sentence was not recommended because the young person didn't suffer from a mental disorder. We really do have an excellent assessment program. They're ready. They're waiting for cases. They've been tracking. There are many, many cases where the offense might qualify, and I think there's a concern that council and the bench are not sufficiently aware of the availability of this sentence. So if I'm going to put in a plug for the correctional authorities, if you think you've got a young person who might qualify for this sentence, by all means, request that the court ask for an assessment to be done.
Thank you. The next topic we're going to deal with is deferred custody under 42(2)P. It's essentially the youth equivalent of an adult conditional sentence. Justice Harris, can you tell us what a deferred custody sentence is and how the serious violent offense, which we've talked about, how that impacts upon whether a deferred custody sentence or not, whether it can be imposed or not, the serious violent offense designation?
Do I have to talk faster than Miriam?
I'm talking too fast now.
I think I quit. It's not possible.
No.
All right. I'm going to say SVO for serious violent offense. The youth court, this is the youth court equivalent of a short conditional sentence. 42(2)P says it can't be longer than 6 months. 42(5) says deferred custody sentence cannot be for a serious violent offense. And secondly, that the deferred custody sentence has to meet at least one of the criteria for custody under Section 39. I'm paraphrasing, but it makes it a custody sentence. So it's a custody sentence that's served for up to 6 months in the community, but a serious violent offense is not eligible. Everybody with me so far? Okay. Now, how do you decide if the offense is a serious violent offense and ineligible? You have to look at Section 2. The definition of serious violent offense is an offense in which a youth causes or attempts to cause serious bodily harm. 42 sub 9 says, after a finding of guilt on application by the Attorney General and after giving both parties an opportunity to be heard, the youth court may make a judicial determination that the offense is an SVO and endorse the information accordingly. So, some courts have held if there's no hearing, no judicial determination, and no endorsement by the court on the information of an SVO under 42.9, then the offense is not an SVO in the legal sense under 42.9, and therefore the offense is eligible for a deferred custody sentence. Well, I think that approach is right on the theory that because this area is so ambiguous, I say the YCJA is a penal statute, that the theory ought to apply that that any penal statute ought to be interpreted in a manner favorable to the accused youth. Now, how do you prove an SVO, and how does it impact on sentence? It's proven in exactly the same way as the Crown proves any aggravating factor on sentence. I say it's beyond a reasonable doubt, and you have to then establish the proof of an SVO by establishing proof that the offense constituted serious bodily harm. To do that, you look at a case like McCraw, Supreme Court of Canada. There's citations in the material. That refers to any physical, psychological injury that substantially interferes with the health, integrity, etc., of the complainant. No, and so if an SVO is proven, then there's no deferred custody sentence available, and the youth has one strike against him or her towards the third serious violent offense and a presumption of an adult sentence. And I say that under 42.9, if the court makes a judicial determination of an SVO, and where it says, and endorses the information accordingly, it follows that lockstep that if the court makes this determination, it has to endorse the information. It seems to follow from the word accordingly. So that's the impact of an SVO on a deferred custody sentence.
Ted, if a young person breaches the deferred custody sentence, what happens then? Is it similar to the community supervision breach?
I was just going to say it is similar. The sections are just a bit different, section 106 through to 109, but it's similar where there's the, if the provincial director finds there's a breach, they can suspend the conditional supervision, remand the youth into custody subject to a youth court justice review, and the youth court justice has similar powers to leave the deferred custody sentence intact, vary or impose conditions, or order the young person to serve the remainder of the order in custody, which would now be which now it would convert to a custody and supervision order. So whatever time was left would convert to a sentence under 42.2N, custody and supervision order.
Okay, thanks. We've got 3 more topics to deal with in about 5 or 6 minutes, so we'll try and deal with these. We may have to skip the reviews and the conferences. But the sentencing principles, I think we might spend just a little time with that. This act is chock full of principles, and how they all apply is subject matter of a lot of litigation. There's principles in Section 3 of the Act that are general to the Act, and sentencing itself under Section 38 and 39, actually 38, and 39 to some extent as well, has its own set of principles. So how do you put these all together, and how do you deal with the normal principles we deal with in criminal court all the time? Firstly, I'll ask Justice Renaud about the application of the Youth Criminal Justice Act to the criminal code provisions of sentencing in Section 718, and specifically with general deterrence. Is it dealt with the same way as with adults?
For the last year, we've been dealing with it in the same fashion simply because I think we haven't spent enough time looking at the legislation and reminding ourselves that this is novel. We all find ourselves speaking of general deterrence, the defense lawyers by reminding us that it doesn't apply, and the Crowns by pointing out that deterrence has to be a result of some element of the equation. If we look at the preamble, if we look at Section 3 and we look at Section 38, in my view, that's a comprehensive code. We don't need to go to 718. 718, in essence, skewers the analysis. If we talk about, as we did earlier, a 39(1)D analysis, an exceptional situation. Well, a person could find themselves in custody with no history, with no prior wrongdoings because of the nature of the offense. For example, desecration of a place of worship. That is a very significant harm to the community. It's a blight on our community. We don't need to go to 718 to speak of general deterrence to know that that person may well face a custodial period by way of enlightenment, dealing with the consequences, dealing with the potential harm, and the public education of the courtroom. So custody is available. That person, if taken into custody, that would serve the elements of general deterrence, but you're not trying to influence other would-be young people in that sense. So I think reference to 718 is not appropriate. Reference to general deterrence is not appropriate. Most judges will say, where is that in legislation, as opposed to what are the principles set out in the preamble, Section 3 and Section 38. I'll apply those and see whether or not there should be an element of general deterrence that arises as a result of what occurs.
All right, there's other principles too that you can look at through there, and the cases in Miriam's compendium really do they're kind of categorized in those areas, so you can look at those cases with respect to a number of other principles that are spoken about in the cases. I'm going to just deal with two other issues. One is reviews, which was part of the Young Offenders Act. Is it essentially the same regime as was under now in the Youth Criminal Justice Act as was under the Young Offenders Act, Miriam?
Pretty much. The two sections that you want to compare are 28 of the YOA with 94 of the YCJA. The only real distinction is that there's an additional option for review available under the YOA of placing the young person on probation, which is not present in the YCJA. And if you want a good comparison, there's actually a case in which Justice Weinberg talks about it when she's trying to decide how the transitional provisions work. And that's also in the summary, but it's RB at 2003 OJ number 1856. But the bottom line is basically the same, but you can have probation under the YCJA.
Thank you. We've got a couple of minutes left to speak just briefly about conferences, and they're provided for under Section 41 of the Act that a judge can call, and Section 19 of the Act that a judge can call a conference, and other people in Section 19, but a judge can call a conference for sentencing purposes. What, Justice Harris, what, in the last 2 minutes that we have, what are these conferences, how are they composed, how do you call them?
I've included a couple of possibilities for conferences in paragraph 1 of my paper. Sections 19 and 41, in my view, are hardly being utilized in the province. Where they are utilized, the type that seems most popular is a kind of conference where the judge is conducting the conference in court and on the record. Now that looks to me like what I call a sentence hearing, but if we adopt that model, I think we won't realize the potential of this feature in the Act. But essentially, there's many different kinds of issues and processes being canvassed in the course of a conference in Ontario. It's basically anarchy, and it's hardly being utilized as far as I could see. And I think a good starting point would be to have somebody inform the Ontario government that the YCJA has been proclaimed in this province. Anybody want to help with that? I guess that's a little unfair because there's fierce pockets of activity, like in Miriam's office, where we're working resolutely towards some kind of scheme where we could all understand what the province will pay for as facilitators, what the province recommends, and what the Crown's guidelines will be for conferencing. But at this stage, there isn't a whole lot happening as far as conferencing in Ontario.
Ms. Blumenfeld, reply?
Well, this isn't a reply, just an additional comment. Across the country, some provinces have more developed regimes with respect to conferences than others, and certainly Ontario is lagging far, 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 far behind. But it appears that in the first year, it doesn't matter how evolved the conferencing services are, the provisions just aren't being used that much across the country, not just here. And where they are being used, and this is relatively anecdotal, but it appears that they're being used sort of as a case management kind of process rather than a restorative justice sort of process.
I'd like to thank all the panelists to cover sentencing in an hour, and we didn't cover everything. It is a monumental task, and I appreciate everybody's input today to the program. Thank you.
Okay.
As you can see, as I mentioned, since Miriam is kind of attached to this panel, as opposed to doing it at the end, we're kind of sliding everything back a little bit. Doesn't mean we won't finish on time. Sergio is moderating a panel on bail, which is scheduled for 25 minutes, just to keep everybody on time. I think we should do that now, and then we can take a 15-minute break after that's over. So I'll call upon the bail panelists to come up.
My pleasure, Richard. It was fun.
I'll get a
relaxing too. No, no, no.
Oh, sure, thank you. Thank you. Thank you. You did? I gotta get you a case again.
Well, I was kind of, actually, I was expecting.
Oh, really?
So I actually thought
It was absolutely huge last year, yeah.
so.
It was
who are
packed.
these people?
Yes. Yes, I've noticed most, yeah.
You recognize a lot of them?
There's a lot of duty councils, you can tell there, but I recognize a lot of, yep,
Yeah.
yeah. I'd say about a good one-third of them I recognize. Yeah. And a friend of mine, she's a con from Stratford, and she's up there, and so I think they're not only from Toronto, but yeah, a lot of those, yeah, one or two crowns, yeah.
I think you're going before me. You're going before me. Oh. Yeah.
I prepared something that I'll be referring to, so that I'd be prepared something so that I'd be able to go.
Yeah, that's a good idea.
Unfortunately, I didn't have it with me when I was.
Now, we're going to be dealing with the bail under the new regime here. As we all know, one of the objectives of the Youth Criminal Justice Act was to reduce the rate of incarceration. And of course, that also applies to the whole issue of bail here. There have been some notable provisions restricting the use of pretrial detention in the Act, as we all know. And from a defense viewpoint, this, of course, was long overdue. As we can all recall, under the Young Offenders Act, at the initial bail stage, and the statistics showed that youths were more likely detained than adults. And the other anomaly was when they were released, presiding justice would often fashion a bail that was, in our minds, from a defense viewpoint, much more restrictive than what the adults were getting. In many cases, it would be a bail of house arrest, and in many cases, even for first-time offenders charged with relatively minor offenses. And of course, the bails were in many cases tied to social measure considerations, which we'll hear are no longer allowed in the Act. I think it's pretty clear now that the YCGA provides for a more principled approach to the bail issue. There's an interesting interplay between the bail provisions, as we all know at this point, and the custody provisions. And it clearly indicates that detention is only warranted after all other alternatives have been canvassed. Now, the question, the two panel members that are here today will be shedding some insight into how these new provisions have played out in the courts. And we have two distinguished members of the panel today. We have His Worship David Hunt, who regularly resides at the 311 Jarvis Courthouse, which is a courthouse that is which is totally focused on youth court matters. And we also have Madam Justice Marion Cohen here, who is also a fixture at 311 Jarvis. She sits there both in youth court and family court. And perhaps we can start with His Worship, and I guess he'll give us some perspective on the bail, under the new regime vis-a-vis the initial bail stage.
Yes, I did prepare a paper, and I put all my thoughts, and I show where I stand on a lot of issues and such things in there. So I won't simply sit and read that, because you've got that, and sometime you can take a look at it. And if you really need to have a good sleep, it may prepare you for that down the road sometime. So I did prepare something else. Sergio had sent us of facts pointing out certain issues that I thought were quite relevant, so I've focused on that for my oral presentation, which I've also written down. Okay, the new act does recognize the importance of patterns of behavior, and this is important where appropriate to allow the Crown adequate time to bring forward allegations of outstanding charges because it can show a consistent pattern or worse, an escalation in the seriousness of offenses that are alleged. Without the information, the court can't really properly assess the young person's needs and structure an appropriate condition or conditions if a release is to be given. So it's not just a case of bring them all forward so that they can be detained, but it actually does come into play for structuring releases. And the bail hearing, of course, isn't part of the sentencing procedure because the defendant is still presumed innocent, and that's a cornerstone of the bail process. But it must be part of the timely intervention as discussed in the Act. And if the prior allegations aren't brought forward, then the defendant potentially is given the impression that there's little or no accountability for his or her acts and that the effects aren't cumulative. The other benefit to allowing the prior allegations to come forward is it allows the parents or the potential sureties to hear the allegations in detail, and they can then assess their willingness to participate in a release, and also allows the court to observe their reaction to the allegations and try to form an opinion on whether they're simply going to summarily dismiss any possibility of fault by the young person, or whether they will take it seriously and, as a result, be more vigilant and effective in their supervision if a release is given. Okay. The next area is the purposes and principles and how they relate to the consideration of bail. Okay. Section 38 of the Act sets out these purposes and principles, and they include considerations of degrees of participation in any offense, and that any penalty must be proportionate to the seriousness of the offense. So the court at the initial bail hearing must look at the allegations that are specific to this defendant and ensure that any delay that would be caused by allowing the Crown time to bring all of the allegations forward isn't going to cause them to suffer a greater penalty with that delay than would happen if they were ultimately found guilty and a sentence was imposed. Okay. On the issue of pretrial conferences, they are a useful tool even at the initial stage, as it gives an opportunity to explore the needs of the defendant and could assist in a more focused search for alternatives to pretrial custody. I've not used one myself, but Justice of the Peace Kowarski did use one a couple of months ago, which did allow him to fashion a release based on finding of programs that were available to the young person. Now, the bail courts would have to make some serious changes to accommodate this type of process, as it's done generally in chambers, and it could be done, in my opinion, in the time period which is normally given for the Crown and defense to discuss issues. But the complicating factor, again, is that the Justice of the Peace is not part of the trial and potentially the sentencing process, so the discussions would be quite limited as to bail issues and would be primarily simply for finding alternatives to custody. Okay. On the issue of social measures, that's covered in my paper to some degree, and I have some comments about what should be provided in terms of facilities. But by those measures, of course, detention is prohibited as a social measure, and it creates a very difficult task for the defense to provide an adequate plan for any young person who has a particular challenge to the traditional facilities, although they are not extremely violent or a very serious threat to public safety. Typically, the Crown sets up the argument of the impossibility of containment and protection of the public in the case of young persons who have a history of breaches of bail orders. And the defense basically argues that the Children's Aid or some other facility would permit their release, is a facility that could permit their release in accordance with the Act. And this leaves the court with a very difficult task of deciding whether the situation is sufficiently grave that the presumption is rebutted by an extraordinary situation and potentially trying to structure a release. So what we're left doing is trying to structure a release with adequate safeguards in most cases. Okay. Now the concept of responsible person is the next thing on the list I was provided. And I'm pleased that the Act does provide for this to be an alternative for the youth who has effective supervision available from someone who has less than adequate financial resources. I've used this tool several times in making releases, but I try to make it clear to the young person that they would otherwise be detained and that this is very much a last chance situation. Unfortunately, my record hasn't been too impressive in the success rate, and there's been several withdrawals by that responsible person. And in one case, the worst case, the young person lasted 6 hours in the community under that person's supervision until being alleged to have committed an identical offense at the identical premises. So not a great success in that case. Okay. Okay. And it would be beneficial for the potential responsible person to get independent legal advice before putting themselves forward for that purpose. But there is a problem in that case because the duty counsel who is conducting the bail hearing cannot readily give that type of legal advice. And I don't know how that problem could be solved. It might be partially remedied by the preparation of some type of an information package in very plain language that could be drafted and made available to individuals who are potentially going to testify at a bail hearing. It would be better, of course, if a second duty counsel would be able to speak to that person and warn them of the potential hazards of that route. Okay, the idea of a responsible person at all is a direct response to the pleas made by parents over the years that they would be wanting to supervise their children and take the consequences if that child committed a further offense. And it's interesting to see how successful this option is, as the emphasis is on quality of supervision, and it will require a good measure of cooperation by the youth. And one of the side benefits would be that if the program is successful, it could lead to much stronger family units because there would be a forced period of cooperation. Okay, thank you. I've covered my points, and the rest are in my paper. Thank you.
Your Worship, just a quick question. In
Sure.
terms of the whole issue of the Crown asking for up to 3 days to prepare its case, do you find that it's being acceded to as much as it was before, given the principles in the Act?
Yeah. Okay, I'm only there when I don't know what other people are doing, but I know that I will give it in what I think are appropriate cases, obviously, but I'm giving it much less regularly than I certainly would sitting in an adult court. So given the new Act, and I've only been sitting under the new Act. Of course, I practiced for 25 years under the old Act and the JDA before that, but I think that there certainly is a requirement that the 3-day rule isn't given carte blanche in the young offenders court, because there is a real focus on not having more custody than is proper under the Act. So I don't just give it automatically at all.
Okay. And on the point of the prohibition of detention as a social measure under 21.1 and 29.2, sorry, that talks about a presumption against detention and the restrictions on custody under 39 and so forth. Do you find that the defense bar at this point is working within this new paradigm, or is it still using the old 515 paradigm, which it still applies, of course, to adults?
Well, to a large extent, I think they're still working under the old regime, and then simply coming forward and saying, this person can be released to Children's Aid. And there's very little set up by way of a program to take care of the structure that may be needed. And in my paper, I did say that I would be very pleased if Children's Aid had available to them some beefed up facilities with more supervision than a crash center, which is often what it ends up as, at least in the short term, so that they could provide more structure and supervision without, obviously, a custodial setting.
Good, thank you.
Because emergency shelters don't have a great appeal, but it's often all I've got to work with.
Right. Thank
The
you.
other point I'll just throw in, it's in the paper and I won't go into it, but I also wish that I had the authority to, if I did detain somebody, put them into open custody as opposed to closed for the thing, and they didn't have to go and waste the time of the provincial court judges. And that would certainly be a great time saver and could save some problems.
Good, thank you. Any questions? No? Okay. And I'd like to ask Madam Justice Cohen now to talk about the bail de novo stage and any developments there.
Yeah.
Well, actually, I'm not going to, I will talk about the bail de novo stage, but I want to talk first about, actually want to talk about release rather than detention, because I do get the impression that there is more release now than there was. So I think that this gatekeeper function that Justice Harris was talking about, the conditions for custody are being looked at in the bail court and more people are being released. However, it seems to me that the big problem that I see is what the form of release. And this is very important because a huge portion of our caseload are failing to comply with releases, failing to comply with recognizance. And so we get to see a lot of these recognizances, and very often these are consent releases. So I think that there is I suppose you've got a desperate client and there's a desperate family, and there is a desperate feeling which motivates an acceptance of conditions of release that you may have doubts about yourself. And I would like to challenge you about that, because some of these conditions of release you can be sure are going to result in failing to comply with the recognizance, and then they're going to be before the court on that charge, and they're going to plead guilty on that charge, and they're going to get sentenced on that charge, and you are going to increase the involvement of your client in the justice system. And really the intent of this act, and I think that your intent as lawyers, is to keep young people out of the courts, because the courts are very, very unhealthy places for people to be. Now, I'm going to, I don't think there's any doubt about that. I'm going to refer to a recognizance. It's just one that happened to come across my dais. But I think in certain respects it's typical, and in certain respects it's not. But I think it's instructive. Sorry.
It's not my client.
Okay. I'm sure neither of you would be involved in this, because I'll just refer to the unusual condition. This is a consent release, and one of the conditions, and there are 6, is comply with the terms of your other bail releases. Now, this is not a sensible or necessary condition. It shouldn't be here. The reason it's here is because there is a desire to teach children. There's a kind of a parental kind of sense that comes into this, and there's a feeling we must stop this, we must do something. And I think it's important to resist these urges, because you find yourself then imposing rules that, as we do as parents, you impose rules that don't make sense, and eventually the day will come. Now, this was on a breach of recognizance. So now he's going to breach his recognizance by breaching his recognizance by breaching his recognizance. It will go on forever. So that was a condition that's in there to kind of teach the kids something, but what is it going to teach him in the end? I'm just going to work from the bottom up then. Keep the peace and be of good behavior. Is that needed? Why is that needed? Because what that means, when that condition is in there, and it's in, of course, all the probation orders, it means that if he gets arrested for another offense, he can be charged with breaching his recognizance by breaching the term of keeping the peace and being of good behavior. And he will plead guilty to that, because that is considered to be an important thing to have on your record, so that the next time, if the person is arrested, the justice will know that there was a failure to comply. But what was if you know that they were found guilty of an offense, why do you need that extra, and it's going to be something that the court will take into consideration in sentencing. Why do we need that in there if it's just going to be for the purpose of getting a record entry? It's not really for the purpose of modifying the behavior, protecting the public. That's what these conditions are for. And protecting the public from a repetition of this particular offense. So that's important to keep in mind too. It should be, I think that the motto should be less is more. Keep it down. I know the desire is to have more, but keep it down. Attend and be amenable to such counseling or treatment as directed by your mother, and take any medications prescribed by your doctor. Now, how can there be a condition, take any medications prescribed by your doctor? If you breach that, what does that have to do with this offense? How is this going to be related to this offense? Perhaps there was a kind of a logic, he's not even listening to his doctor. But again, remember, we are not the parent. That is not what this court is for. You are representing the youth, and we are dealing with the youth. We are not representing the parent. We are not in that role. We're not going to make sure that he comes home and does at the right time after school. We're not going to watch who his friends are unless they're specifically involved in this offense. We're not going to make sure he does his homework. This is not what our role is. We are a very blunt system. We were putting kids into an institution that has to be closed down in Toronto. And we knew what was going on there. We saw kids coming into court with bruises and with black eyes. We knew what was going on. So that is how blunt our instrument is. And there's very little we can do about it. This is a system, and we all work within it, and we all do our best within it. But we have to remember how powerful it is. So we want to stop the behavior. We want to stop the criminality, but we shouldn't kind of do more than we really can do. And I think that these kinds of conditions take us way beyond what we should be doing. Attend school each and every day. Each and every class is required not to be absent from school unless you have written permission from school principal or your mother, and show proof of your school attendance to your mother. Now, the mother was there for sure, and the mother got this condition in. I agree that going to school is very important. It's one of the most important things that we want kids to do. We know that going to school is their hope for the future. But not every kid can function in school. And a lot of these kids, and Sandra Lang was saying it, a lot of these kids have learning disabilities. A lot of these kids have problems at home. Not every kid can get a written note from their mother every time, or is going to be safe getting a written note from a parent. So, and then what happens when we get the fail to comply? We're going to punish someone for truancy. Now, we don't bring truants into court. When I started as a judge in Etobicoke, we actually had truancy in the court. And it became absurd because we have all these other very serious offenses, and so how could we really focus on truancy? Truancy doesn't fit in the kind of youth justice system that we have now. And yet, if they breach this condition, and they may not have even committed this offense during school hours. I mean, this could have been something that happened after school. So we have to question this condition. Then we have, of course, the most common condition, which is the house arrest. And the house arrest, again, I understand why these things come about, because we don't want them to be in jail. And so the preference is to have them in the house rather than in the jail. But think about the house. Some of these houses have 5 or 6 people living in very small quarters. Perhaps they've got a 2-bedroom apartment. There's a lot of people in there. We've got perhaps a single parent who has babies, small children, trying to get kids to go to and from school, multiple problems in the home. This is the house that we are going to say that this teenager, who could be 16 or 17, a big kid, is going to be in that house all the time. And then he can't leave the house. So now there is a growing perception that this is a problem because the kid may have to go to the doctor, may have to go to the hospital, has to go to school. And so now we put a lot of conditions on that. Okay, exceptions. You can go to your lawyer's office, you can go to court, you can go to school, you can be with your mother, or you can go to counseling. Does that cover everything? What happens if he has to leave the house to get a bottle of milk because the mother can't leave and the baby's crying? And this happens. We have these children arrested right outside the variety store, down the street from where they live, just because of that. Now, what you're asking here is you're asking for this child to breach their bail, but figure it's okay. In other words, we're kind of almost setting up psychologically a problem. They know they have to do it. The parent tells them to do it. The bail says they can't do it, but they have to. Who's right? And that puts them in a conflict, and I don't think that's really something that favors rehabilitation. So I think that these house arrests are a very big problem. They're breached all the time. And remember how long it takes to get to trial in our jurisdiction. And I don't know what goes on in other jurisdictions, but our courts are overcrowded. We have delays, tremendous delays. And that means this house arrest is not going to be for 4 weeks or 8 weeks. It may be for months and months and months. So I think that that's something we have to consider. Reside with your surety and be amenable to the rules and discipline of the home. That's fine. Obviously, if the sureties, I think that that's good because you are giving the parent responsibility and an ability to control the child and to supervise, which is what we want. Don't specify the address because a lot of people move a lot and that creates problems. But these are the terms then that are in this particular bail, and I think they're very problematic. There's a couple of other things that I think are problematic. I think boundary conditions are very problematic. I know there are bad areas of the city, sometimes where there's a lot of drug trafficking or there's a high crime area. A lot of people live very close to these areas, or the boundary may include the entire subway line, or it may include Sick Kids Hospital. We got to be very careful. Or the boundary may say 100 meters. Now, they do know what meters are. I don't know what a meter is, but 100, I don't know how far 100 meters is from where they're supposed to be. And how do they know? I think don't go to that house. Stay away from this particular spot. But the whole boundary becomes, I think, a problem. And finally, the last problem, I think, is when you name the school. Now, we have a big problem with kids being kicked out of school. And then they're kicked out of this whole school board, then they can't go to school, and then they're sitting around and presumably, or one thinks perhaps they're going to commit more crimes because of it. So it is a problem that they're being suspended and expelled from school. But let's leave those decisions at least with the Board of Education and the school principal. Let's not make the decision that they can't go back to their school. Because maybe the principal today doesn't want them back, but perhaps a month from now the principal may want them back. And we don't need to have it in the bail that they can't go there and they've got to start looking for another school. So that's it. And my 10 minutes are up?
Pretty well, yeah.
Okay, 2 seconds, 2 seconds on bail de novo. Just remember that this is not, can I do it?
Oh, go ahead.
Okay. It's not an adult, so we're not interested in, how much money the parents make, and we're not interested in what their immigration status or whether they're Canadian citizens, and we're not interested in the answer to the standard question. I mean, I suppose you have to ask it, I don't know, but, if you are released, will you abide by these conditions? Yes, I will. That is not enough for a bail hearing. If you're going to do a bail de novo, try to get a plan. Always, I would say, once you're representing a kid, your main focus is developing the plan. The plan is critical for bail, it's critical for sentencing. Get a plan, have the plan, that's what we're interested in. If you've got a plan, and I'm just going to say one last thing.
Go ahead.
Don't be afraid if there's no residence. 16 and 17-year-olds may not have a residence. If they're under 16, the Children's Aid Society has to furnish one if they haven't got one, because then they are an abandoned child. If they're 16 and 17, there are shelters. If the offense is a minor one, don't be afraid of the fact they don't have a residence. Go ahead. There are shelters, there are places, they will find places to live. What we want is we want to get them to court, and we don't want them to commit other offenses. And we can't punish them because they're homeless. That's it.
Thank you very much. I'd like to thank both panel members. And it's time for our break until
11:15, you can come back at 11:15.
11:15, great. Thank you. Excellent. Lots of passion.